Hey, Lorenzo. So we are jumping into an exploration of Republic Act 7610 today. It's the shield of the state in the Philippines.
Right, yeah, a really crucial piece of legislation.
Exactly. And it's basically a survival guide to understanding child rights and state responsibility. But there's this core concept called first call for children.
Yeah, so first call for children is, it's this idea that the state is the ultimate backup. Like, if parents or teachers fail, the state doesn't just wait around for an invitation.
Right.
It actually has a mandatory obligation to step in.
Wow, okay. But let's talk about the definition of vulnerability here, because the way they define a child is kind of wild.
Yeah.
You could be like 25 years old and still be legally classified as a child.
I know, it sounds like a glitch in the system, right?
Yeah, it feels like it could be patronizing or just legally really messy.
Well, it's actually a very deliberate feature. It's about the smart nature of the law. So if someone is over 18 but has a physical or mental condition where they can't fully protect themselves,
Oh, I see.
or, compete in society, the law extends the child designation to them. It shifts childhood from just a chronological number to like a functional state of being.
So it's less about how old are you and more about how much power do you actually have.
Exactly. If you can't defend yourself, the state decides you deserve the same high-level protection as a toddler.
That's actually a really great analogy, like a smart safety net that adjusts its mesh size depending on the person. And I guess that logic flows right into the 4 pillars of abuse.
Yes, the 4 pillars. Because abuse isn't just physical violence.
Right. It covers psychological harm, degrading acts, and depriving someone of basic needs like food, shelter, or even withholding medical treatment.
Exactly. And they treat withholding medicine as basically the same as actual physical assault.
Wait, really? The same as assault?
Yeah, because the law views a child's development like a structural foundation. If you deprive them of medicine or dignity, you're causing structural damage that can be just as permanent as a broken bone.
I see the logic, but the penalties feel almost extreme. We're talking about reclusion perpetua for things like child prostitution or trafficking.
Which is, a very heavy penalty.
Yeah. For those who don't know, that isn't just a standard life sentence where you might get out in a few years. It's a specific 20 to 40-year term, and it carries much stricter parole conditions, especially if the victim is under 16.
And the penalties actually spike even higher if the offender is a relative or a public official.
Because of the breach of trust.
Exactly. It's an aggravated circumstance. And, fun fact, if a foreigner is convicted, they're deported the exact moment they finish their sentence.
Just immediately kicked out.
Right. The logic is, if you come here and violate the most vulnerable, you just completely lose the privilege of being part of this society.
That makes total sense. So I want to pivot a bit to the indigenous and conflict rights. The law has these special protections where children are declared zones of peace.
Yes, indigenous kids get culturally specific education and health protections.
Right. And in armed conflict, they obviously can't be used as combatants. But the law is incredibly specific about forbidding them from being couriers or spies.
Very specific, yeah.
Why so pedantic about these non-combat roles? I mean, to a kid, being a messenger might feel like a low-risk job, right?
Well, because that's the trap. That is exactly what recruiters in conflict zones tell children. They say, hey, you're not a soldier, you're just carrying a letter.
Oh, man. So it makes the child feel safe.
Exactly, while actually painting a huge target on their back. So by naming these roles, the law creates a geographical sanctuary. If a child is there, the rules of war are physically suspended. Right. That area is totally off limits for military activity.
Okay, that's powerful. But here's where I kind of have to push back. The enforcement side of this, the law allows any 3 concerned citizens to file a complaint.
Right, the village approach.
Yeah, but on paper, that sounds great. But in reality, couldn't that just be a weapon for malicious neighbors? Like, if I don't like the family next door, I grab 2 friends, and suddenly we trigger a massive state investigation. Isn't that just a recipe for harassment?
It's a totally valid concern, but the law actually builds in a filter for that.
Oh, it does?
Yeah, those 3 citizens don't trigger an immediate police arrest. They trigger an investigation by the DSWD, which is the Social Welfare Department.
Ah, okay, so it's not like SWAT is kicking down the door.
Right, exactly. The whole rule is a direct strike against the bystander effect. People see abuse and think, oh, it's a family matter, I shouldn't interfere.
Oh, for sure. That happens all the time.
Yeah, so this law says, no, silence is not an option when a family is complicit. It's designed to break that wall of silence that protects abusers.
And once that wall is broken, The state actually goes into stealth mode, right? With confidentiality.
Yeah.
They strictly forbid the media from reporting names or details.
Yes, to prevent moral degradation.
So it's not just about their reputation today, it's about making sure they aren't frozen in their trauma by public records for the rest of their lives.
Exactly. It's about preserving their future identity. The whole thing is a really comprehensive framework that insists a child's dignity is non-negotiable, from the courtroom to the battlefield.
It really is. And it effectively deputizes every member of the public. So, Lorenzo, here's a thought for you. The next time you see something that feels off in your community, remember those 4 pillars: physical, psychological, basic needs, and medical care.
Keep them in mind.
Yeah. If you saw one of them being shaken today, would you be able to move past being a bystander? Or would you just be waiting for someone else to be the first of those 3 citizens?
All right, today we're tackling a really important piece of legislation, a law that was literally designed to be a shield for the most vulnerable people in our society. We're going to break down Republic Act 7610, which is also known as the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. It's a big one, but it's so important. So let's dive in.
You know, right at the heart of it all is this one powerful idea. This single sentence pretty much sets the stage for everything else in the law. It's a simple, non-negotiable rule. Whatever is happening, whatever decision is being made, the child's well-being has to come first, always. Think of it as the guiding star for this entire law.
And this is where the law really shows its teeth. It's basically a promise, a formal declaration from the government saying, hey, if a parent, a guardian, or anyone else fails to protect a child, or worse, is the one causing the harm, we will step in. It makes it clear that protecting kids isn't just a family issue, it's a fundamental duty of the state. Okay, so to really get how this shield works, we've got to understand the ground rules first. I mean, what does the law even mean when it says child or abuse? These definitions are absolutely crucial because they draw the lines in the sand for who gets protected and what they're protected from.
And check this out, what's so important about this definition is how inclusive it is. The law doesn't just stop at the age of 18. Nope, it actually extends that protection to adults who, because of a disability, might be just as vulnerable as a child. So it's a definition based on vulnerability, not just on a birthday. Now, the definition of child abuse itself is super broad. Maltreatment, whether habitual or not. And that phrasing is completely intentional. It's designed to make it clear that an act doesn't have to happen over and over again to be considered abuse. Even a single, terrible act of maltreatment can and does fall under this law.
And the law doesn't just leave us guessing what maltreatment means. It gives us very clear, concrete examples. Of course, it covers the obvious stuff like physical and sexual abuse, but it also includes the more insidious things, like words that destroy a child's self-worth, or deliberately withholding food, or failing to get a kid medical help when they desperately need it. All of these are seen as clear violations.
So beyond that general definition of abuse, the law zooms in on what it considers 3 of the absolute gravest dangers a child could possibly face. These crimes are so serious that they each get their very own dedicated articles within the act. Yep, 3. The law puts a giant red flag on 3 specific types of exploitation, and it targets them with some really severe penalties. Let's take a look at the first one. First up is child prostitution. The law is airtight here. It is illegal to engage, promote, or even help facilitate the sexual exploitation of a child for any kind of payment. And it doesn't just target the clients, it targets the entire network of people who would allow this crime to happen. The second core danger is child trafficking. This part of the law is aimed at the absolutely horrific act of treating a child like a product. It explicitly outlaws the buying, selling, or even bartering of children. It's a direct attack on the monstrous idea that a human being could ever be for sale. And the third major crime the law targets is using children in pornographic materials or indecent shows. This covers everything from forcing a child to perform in some live show to making them model for obscene photos or videos. It's all about protecting a child's innocence and their image from being exploited. But the law's shield doesn't stop there. It actually recognizes that some groups of children face unique and even greater risks. So for them, it provides an extra specific layer of protection. As you can see here, the law gives this special attention to 3 different groups: working children, children from indigenous communities, and kids caught in the crossfire of armed conflicts. So let's break down what the law says for each of them. For any child under 15, the general rule is simple: employment is not allowed, period. But the law recognizes life can be complicated, so it allows for 2 very narrow, very tightly regulated exceptions.
First, if they work for their own parents, as long as it's safe and doesn't get in the way of their schooling. And second, for things like movies or TV, but only with a government permit and super strict rules to protect the child's health and education. Now, this next part is honestly incredibly forward-thinking. It's all about protecting indigenous children. The law requires that their unique cultures and customs be respected. It guarantees them education that's culturally relevant. It puts them at the front of the line for health services. And, maybe most importantly, it makes any form of discrimination against them totally illegal. And for children who find themselves in the middle of an armed conflict, the law is absolutely unequivocal. It declares them to be zones of peace. What does that mean? It means they cannot be recruited by armed groups. It means essential services like food and medicine must be allowed to reach them. And it means in any evacuation, they are the #1 priority. Okay, so we have this incredibly powerful shield of protections. But a shield isn't very useful if you don't know how to pick it up and use it, right? So let's look at the path to justice, the actual procedures that turn all these words into real action. This right here, this might be one of the most powerful parts of the whole law. Just look at this list of who can file a complaint. It's not just the child or their parents. A relative, a social worker, a local community leader, or even a group of just 3 concerned citizens can get the ball rolling. This was done on purpose, to create a massive safety net and empower the entire community to speak up. And as soon as that complaint is filed, the law has 2 critical procedures that kick in to protect the child. First is protective custody. This means immediately getting the child out of a dangerous situation and into the care of social welfare. It's about safety right now. And second, confidentiality. This is so important. It shields the child from being re-traumatized by public attention. The law actually makes it illegal for the media to create a big spectacle out of the case. So as we've seen, Republic Act 7610 is so much more than just a dry legal document. It's a full-on framework built to protect, defend, and uphold the dignity of every single child. It really is a powerful shield. And that kind of leaves us with one last big question to think about. How can we, as a community, make sure this shield isn't just words on a piece of paper, but a living, breathing reality for every single child who needs it?
So I want you to imagine, just for a second, trying to design a security system. And I don't mean like for a bank vault or some priceless museum exhibit.
Right, something way more complex.
Exactly. I'm talking about designing a security system for a human being, specifically for a nation's most vulnerable population, its children.
Yeah, which is an incredibly daunting task.
It really is, because you aren't building this out of titanium or surveillance cameras. You're trying to engineer this massive legal architecture.
Yeah.
And it's built entirely out of words.
Just words on paper.
Right. Words that have to somehow anticipate the absolute darkest, most horrifying parts of human behavior.
And the really incredible difficulty of that specific engineering challenge is that this system, it can't just be this thick, impenetrable wall.
What do you mean?
Well, it has to be highly permeable. I mean, it has to allow a child to actually live a normal life, right? To go to school, to interact with adults, to be part of a family.
To navigate a world that is, frankly, often pretty dangerous.
Exactly. You can't just lock them in a safe.
Yeah. So today we are doing a deep dive into one of the most comprehensive and honestly aggressive pieces of child protection legislation on the planet.
It really is a fascinating legal document.
We're looking at the Philippines Republic Act 7610. Alongside its massive recent update, which is Republic Act 1116-48.
And just to set the stage, our mission for this deep dive isn't just to, read through a dry list of legal penalties.
No, absolutely not. We want to understand how a society actually defines abuse on paper. How does it spot the economic loopholes that predators exploit?
Yeah, and how it manages to balance the need for this absolute uncompromising protection with, the very complicated realities of severe poverty or cultural differences.
Even active armed conflict.
Right, because when you really study this text, you start to realize it is trying to account for almost every conceivable threat a child might face.
It's sweeping. So, okay, let's unpack this. Before we get into how this law punishes the bad guys, we really need to understand the baseline.
The foundation.
Exactly. We need to look at exactly who this law protects and what it considers a threat. Because the definitions here are, they're surprisingly profound.
They really are. I mean, in most legal frameworks, the definition of a child is strictly chronological.
Right. You blow out 18 candles on a birthday cake and poof, you're an adult.
Exactly. Fully responsible for yourself in the eyes of the law. Now, this law It does start with that standard baseline, persons below 18 years of age.
Okay, pretty standard.
But then it adds this vital functional caveat. It explicitly extends the definition of a child to include anyone over the age of 18 who is unable to fully take care of themselves.
Wait, really? So an adult can be legally classified as a child here?
Under this specific protection, yes. If they can't protect themselves from abuse, neglect, cruelty, or exploitation because of a physical or mental disability.
Wow. That's a massive conceptual shift.
It changes everything.
Yeah. The law is moving the definition of childhood from like a strict date on a birth certificate to a metric of functional vulnerability.
Precisely. It acknowledges that the core purpose of child protection laws isn't really about age at all. It's about an extreme imbalance of power.
Right. The power dynamic is what matters.
Exactly. So if a severe cognitive or physical disability creates an imbalance of power that renders a 25-year-old completely unable to defend themselves against a predator.
The state basically says, we've got you too.
Yes. The state extends this entire legal architecture right over them as well. They are afforded the exact same maximum protections as a 10-year-old.
That is amazing. And speaking of the state, this brings up one of the most striking declarations early in the text.
Oh, the intervention clause.
Yes. The law explicitly grants the state the ultimate authority to intervene on behalf of the child. It basically says the state shall intervene when the parent or guardian or whoever has custody fails to protect the child.
Or is actually the one committing the abuse, yeah.
Right. Now, wait, hold on. I'm looking at this from the perspective of standard family autonomy. Isn't that a huge legal leap for the government to step in and explicitly override parental authority?
It's a massive leap.
Right, because we usually treat the family unit as this sacred private sphere, giving the state the power to essentially knock on the door and say, you know what, you're failing as a parent, we're taking over. That seems ripe for overreach.
Well, it is a profound exertion of state power.
Yeah.
And it's a tension that legal scholars grapple with constantly. Like, where exactly does a parent's right end and the state's obligation begin?
It's a blurry line.
It is. But the law balances this heavy hand by anchoring itself to a very specific, internationally recognized principle.
Which is?
The best interests of children. The law states that this principle shall be the paramount consideration in all actions concerning them.
Okay. That's
Yeah.
aligned with the UN Convention on the Rights of the Child.
Yeah,
right.
exactly.
Directly aligned.
So the state is acting as the ultimate guarantor of safety.
Yes. The underlying philosophy here is that, sure, the state respects the family unit, but its ultimate loyalty, if there's call, as they put it, is to the physical and psychological safety of the individual child. Meaning a child isn't just the property of their parents.
Right. They are an individual citizen with inherent rights. If the family unit, which is supposed to be that primary layer of protection,
The inner shield, basically.
right, if that shield becomes the source of the threat, the state's fundamental obligation to the citizen supersedes the parent's right to custody.
Wow. That totally reframes the whole concept of custody. And that philosophy really bleeds into how this law actually defines child abuse.
It broadens it significantly.
Yeah, because when most people hear the word abuse, the immediate visceral image is physical violence, right?
Bruises, broken bones, the obvious stuff.
Exactly. But this text casts a much, much wider net. I mean, it details psychological abuse, emotional maltreatment, unreasonable deprivation of basic needs like food and shelter.
And there's one specific phrase in that definition that is just incredible.
Yes, I know exactly which one you mean. It stopped me in my tracks too.
The inclusion of the phrase intrinsic worth.
Intrinsic worth. Yeah. The law defines abuse as any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being.
Finding a concept like intrinsic worth in a strict, highly punitive penal code is remarkable. Usually, penal codes are incredibly cold and clinical.
Right. It's incredibly poetic for a legal document. But how does that actually play out in the real world? Debasing intrinsic worth. It essentially means the law is acknowledging that emotional destruction is a legally punishable offense.
It does. And it creates a very high bar for caregivers. It's saying that a child doesn't just have a legal right to a beating-free existence.
They have a right to more than just physical safety.
Exactly. They have a legal right to human dignity, to self-worth.
That's empowered.
If an adult uses systematic verbal degradation or extreme humiliation or, psychological terror to destroy a child's sense of being a valid human being, that is treated with immense legal gravity.
But proving psychological abuse in a court of law is notoriously difficult, isn't it? I mean, emotional scars don't show up on an X-ray.
No, they don't. It requires expert testimony from child psychologists, detailed behavioral assessments, the whole 9 yards.
It's a complex process.
Very. But by codifying intrinsic dignity directly into the statute, the law gives prosecutors the legal vocabulary they need. They can go after abusers who never lay a single finger on the child.
It really makes you wonder, doesn't it? Like, for you listening right now, if you look at the laws in your own local jurisdiction, do they protect a child's intrinsic worth or just their physical body?
Most only focus on the physical.
Right. It's such a beautifully empathetic way to design a justice system. But, and this is a big but, this law doesn't just look at interpersonal one-on-one abuse.
No, it goes much wider.
It also identifies circumstances which gravely threaten or endanger the survival and normal development of children. And we are talking about bad people here. We're talking about bad environments.
Exactly. The law is highly proactive. It doesn't just sit back and wait for a specific villain to commit a specific crime against a specific victim.
Right. It's not just reactive.
It actively identifies toxic, high-risk environments. It explicitly lists conditions like being in a community with active armed conflict.
Or working under hazardous conditions.
Yes. Or living on the streets of urban or rural areas without parents or basic services, extreme poverty, man-made or natural disasters.
It's like a highly advanced architectural blueprint.
How so?
Well, it doesn't just tell you how to build the walls of the house. It mandates that you analyze the soil quality, the historic seismic activity of the fault line, the flood risks of the entire neighborhood.
That's a great analogy. It recognizes that extreme systemic poverty or a devastating typhoon can be just as abusive to a child's development as a violent parent.
It really is a holistic view.
And that holistic view is essential for the law to work. It mandates that the Department of Justice and the Department of Social Welfare and Development, the DSWD, have to coordinate closely with other state agencies.
To build a comprehensive program.
Right. It's a statutory recognition that you cannot separate child protection from economic stability or urban planning or disaster response.
Right. If a child is living on the street after an earthquake, the environment itself is actively abusing them.
Exactly. And the state is legally mandated to intervene.
So the law aggressively defines the baseline of human dignity, and it maps out these environmental threats. But inevitably, we have to transition into how the law attacks the darkest, most predatory elements of society.
The heavy artillery.
Exactly. We are moving into its total war on child prostitution and human trafficking. And what really stands out when you read these sections is how the law targets the entire economic ecosystem behind these crimes.
It's a crucial evolution in legal strategy.
It doesn't just go after the primary abuser, it goes after the entire supply chain.
Yes. When dealing with child prostitution, sexual abuse, and trafficking, the law imposes maximum penalties. We're talking about reclusion perpetua.
Okay, let's define that really quick because it's a specific term in Philippine penal law. That's not just, a few years in a county jail.
Not at all. Reclusion perpetua is one of the heaviest penalties available in their system. It generally means imprisonment for 20 to 40 years.
Wow.
Without the possibility of pardon before a set minimum of decades is served. And it carries heavy accessory penalties. It is the full, crushing weight of state sanction.
And the law doesn't just drop this hammer on the person who actually commits the act, right?
No. The text heavily penalizes the procurers, the people who promote, facilitate, or induce the prostitution.
Some middlemen.
Exactly.
Okay.
But it also goes after the marketing department, so to speak.
The marketing department.
Anyone who induces a person to be a client through written or oral advertisements. And critically, it goes after the infrastructure, the profiteers.
So the people running the venues.
Right. Those who derive profit or advantage, whether as the manager or the owner of the establishment where it takes place, the sauna, the disco, the bar, the resort, the hotel.
Because the law recognizes a really grim reality here. These severe forms of abuse are industries.
They absolutely are. They operate on the basic principles of supply, demand, and overhead.
Right. And if a justice system only punishes the end user like the client or the immediate street-level pimp, the syndicate just replaces them.
They're just treated as expendable, the cost of doing business.
But by targeting the owners of the real estate, the people profiting indirectly at the top of the chain, the law attempts to make the business model itself far too risky to operate.
It aims to bankrupt the exploitation by cutting off its physical venues and its financial lifeblood.
It's a very strategic attack. And to tighten that net even further, the law utilizes something called attempt clauses.
These are vital.
Here's where it gets really interesting, because a crime doesn't actually have to be completed for the hammer to fall.
No, it doesn't.
The law defines an attempt to commit child prostitution very specifically. It says if any person who is not a relative is found alone with a child inside a room, a motel, a hidden or secluded area.
Under circumstances which would lead a reasonable person to believe that the child is about to be exploited.
Right. That is legally considered an attempt.
It's a very aggressive, highly preemptive legal posture.
But wait, let's play this out in the real world for a second. If a non-relative is found alone in a room with a minor, that is instantly a heavily punishable attempted crime.
Under certain conditions, yes.
That sounds incredibly dangerous for everyday interactions, doesn't it? Like, what if a high school tutor is working with a student in a private study room? Or a family friend is driving a kid home and their car breaks down on a secluded road?
Yeah, it's a very valid concern.
How does the law prevent just an absolute avalanche of false accusations?
Well, it's exactly why the text relies so heavily on that legal standard. Under circumstances which would lead a reasonable person to believe. The context of the environment is everything.
Okay, so context is the filter.
Exactly. The law isn't saying that anytime an adult is alone with a child, it's a crime. It specifically lists historically illicit or highly transient private environments.
Like inns, motels, pension houses.
Right. Secluded cabins in maritime vessels. In a courtroom, the burden of proof rests heavily on demonstrating that the context, the environment, and the behavior strongly indicated imminent exploitation.
So it's like a legal smoke detector.
That's a good way to put it.
It doesn't wait for the house to burn down, meaning it doesn't wait for the child to be actively traumatized. It goes off the second the environmental conditions reach a dangerous threshold.
Exactly. If law enforcement raids a known seedy motel and finds a 50-year-old foreign national alone in a room with an undocumented 14-year-old who isn't a relative.
The police don't have to wait for an assault to begin to make the arrest.
No. The circumstantial evidence of the location, the lack of relationship, the lack of a legitimate reason for being there, that constitutes the attempt. It allows for preventive justice.
And this preemptive strike mentality applies to human trafficking as well, doesn't it?
It does. The law details attempts to commit child trafficking with similar environmental triggers.
Like what?
Well, for example, if a child is traveling alone to a foreign country without a valid reason and without a written clearance from the DSWD or a verifiable permit from their parents, that travel itself is legally considered an attempt at trafficking.
Wow. So it's brilliant because it builds checkpoints directly into normal societal functions.
Exactly. It essentially deputizes airline ticket agents, customs workers, immigration officers. They become the censors for this protection system.
If an unaccompanied minor tries to board an international flight without the right papers, the whole system just halts.
Right. But the text gets even more granular and, frankly, quite dark regarding the mechanics of these trafficking syndicates.
Yeah, this part really got to me. It explicitly criminalizes the act of recruiting women or couples to bear children specifically for the purpose of trafficking them.
Yes, and it explicitly targets medical professionals, doctors, nurses, midwives who simulate birth for the purpose of trafficking.
Simulate birth. That phrasing is just chilling.
It is.
How does that actually work in practice? I mean, how do you simulate a birth?
By dissecting this specific clause, we see the drafters of the law anticipating incredibly sophisticated, well-funded syndicates. We aren't just talking about disorganized criminals snatching children off the street.
Right.
Simulating a birth involves corrupt medical professionals creating entirely forged medical histories, faking prenatal care records, signing fraudulent birth certificates right there in the delivery room.
So they are legally washing the identity of the child from day one.
Yes. They are establishing false parentage immediately. And they often target highly vulnerable, unregistered mothers living in extreme poverty.
So the corrupt doctor delivers the baby but registers it under the name of the trafficker.
Or the paying buyer. On paper, it looks like a completely legitimate birth, which makes the child incredibly easy to traffic internationally under the guise of adoption or just legitimate travel.
That is terrifying.
It is. The law acknowledges that the corruption can reach the highest levels of trusted hospital administration, and it brings the full weight of reclusion perpetua down on the doctors who facilitate it.
It shows a stark awareness of the real-world mechanics of these crimes.
Absolutely.
Now, we also need to talk about why this law had to be updated in the first place, because Republic Act 1148, which was passed recently, changed some very important numbers in the original 1992 text.
Yes, it did. And those changes are critical.
Originally, the absolute maximum penalties for these horrific crimes, the prostitution, the trafficking, they applied only when the victim was under 12 years of age.
Which is a very low threshold.
Right. But RA 1148 raised those age thresholds significantly, didn't it?
It was a monumental shift. For child prostitution, severe sexual abuse, and trafficking, the age for imposing the maximum penalty was raised from under 12 to under 16 years of age.
Okay.
And for using a child as a performer or subject in obscene publications and indecent shows, the age triggering the maximum penalty was raised from under 12 to under 18.
So why did they need to amend this? I mean, what was the logic behind jumping from 12 to 16 or 12 to 18?
Well, it reflects a vital evolution in our sociological and neuroscientific understanding of adolescence.
Okay, unpack that for me.
Back in 1992, there might have been this lingering legal presumption that, a 14 or 15-year-old had a different level of agency.
Like they were somehow slightly less vulnerable to coercion than a prepubescent child.
Exactly. But decades of developmental psychology, neuroscience, and tragic data from trafficking task forces have made it abundantly clear that adolescents are actually extraordinarily vulnerable.
Right, because they're in that phase where they are desperately looking for identity, for belonging.
Precisely. Their brain's prefrontal cortex, which is the area responsible for long-term risk assessment and understanding complex manipulation, it's still deeply under construction.
And syndicates know this.
They absolutely know this.
Yeah.
They groom teenagers by exploiting their desire for independence or by offering them a false sense of security.
So RA 1148 is basically the legal system finally catching up with the science of human development.
Yes. It formally recognizes that a 15-year-old who is being groomed and trafficked requires the exact same level of uncompromising state protection as an 11-year-old.
The vulnerability is just as deep.
Exactly, even if it looks different on the surface.
The system had a blind spot in the teenage years, and they patched it.
They did.
And before we move out of this dark economic ecosystem, we have to highlight the physical sanctions on the establishments themselves.
This is a very effective part of the law.
Yeah, because if a hotel or a sauna or a travel agency is found to promote or facilitate these crimes, the law doesn't just fine them.
No, fines are just the cost of doing business for some place.
Exactly. They are immediately closed, their business license is canceled, and the DSWD is mandated to conspicuously display a prominent off-limit sign outside the building for at least 1 year.
And crucially, removing or tampering with that sign is a separate punishable crime.
It's a literal scarlet letter on the building. It's a mechanism for public shaming and absolute economic ruin.
It is.
Think about the ripple effect of this. It makes child protection the urgent, undeniable problem of every single business owner.
Because the stakes are too high to ignore it.
Right. If you are a hotel manager and you decide to turn a blind eye to the suspicious activity in room 204 just to save your profit margin, you don't just risk a fine.
You risk losing your entire livelihood, your license.
And having a neon sign on your door telling the whole city exactly why you were shut down.
It aggressively attacks the apathy of the private sector. It forces the legitimate economy to police itself.
So the law relentlessly hunts down the black market exploitation of syndicates and traffickers. But what happens when the intersection of children and the economy happens in broad daylight?
When it's not hidden in the shadows.
Right, when it happens in the legitimate, formal economy. We are moving from the black and white shadows into these highly complex gray areas, the strict rules for working children.
And this is where the drafters of the law really had to navigate immense friction.
Friction between what?
Between the idealized concept of childhood, school, play, safety, and the stark, unforgiving realities of poverty in specific industries.
Right. So the baseline rule established here is crystal clear. Children below 15 years of age cannot work. Full stop.
General rule, yes.
But as with any complex architecture, there are load-bearing exceptions. And examining these exceptions is fascinating because it shows how the state tries to regulate what it cannot entirely eliminate.
Exactly. You can't just legislate poverty away.
So exception number 1 is the family exception. A child under 15 can work if they are directly under the sole responsibility of their parents or legal guardian.
And this is key. Only members of the employer's family are employed.
Right. So we were talking about the traditional family farm.
The small family-run corner store, the artisan workshop.
Yeah. But notice the intense conditions attached to that exception. It's not a blank check for parents to use their kids as free, unregulated labor.
Not at all.
The law states the employment absolutely cannot endanger their life, safety, health, or morals. It cannot impair their normal development. And critically, the parent must provide the child with the prescribed primary or secondary education.
The law essentially acts as a hyper-vigilant supervisor looking over the shoulder of the parent.
Yeah, it acknowledges the economic necessity of the family farm, but it draws a hard line.
It says, you can have your teenager help harvest the crops or help stock the shelves.
But the second that labor causes them to drop out of school or suffer physical exhaustion,
You are no longer a struggling parent doing your best. You are breaking a federal child labor law.
And then there is the second major exception, which is even more heavily regulated.
The entertainment industry.
Right. The law says a child can participate in public entertainment or information through cinema, theater, radio, or television, but only if their participation is deemed essential.
And that word essential is the legal fulcrum.
Exactly. Because who defines what is essential? Like, if I'm a TV producer making a soap opera, I could argue that having a cute kid in the background is essential to the realism of the scene. Doesn't that leave a massive loophole for Hollywood-style exploitation?
It absolutely would if the producer were the one making that determination.
Ah, okay. So who does make it?
The law removes that power from the employer entirely. It requires a strict formal permit from the Department of Labor and Employment, the DOLE.
So the government agency acts as the gatekeeper.
Yes. And the requirements to acquire that DOLE permit are incredibly steep. The employer has to prove they have instituted comprehensive measures to prevent exploitation regarding pay, working hours, and physical safety.
But the most progressive, forward-thinking part of this regulation is the educational mandate, isn't it?
I think so, yes.
The text states the employer must formulate and implement a continuing program for training and skill acquisition of the child.
It's a remarkable piece of legislation.
It really is.
That state is saying to the entertainment industry, look, if you are going to profit off the labor, the charisma, and the image of a child, you owe them long-term human capital in return.
You can't just use them up and throw them away.
Exactly. You cannot just use a child actor for their immediate cute factor when they're 8 years old, exhaust them on a set, and then discard them when they hit puberty and outgrow the role.
Right. You are legally required to actively contribute to their long-term transferable skill acquisition.
It is a phenomenal way to protect a child's future earning potential.
It really brings up a massive, glaring question about today's digital landscape.
Hello, the influencer economy.
Yes, because these laws were written in 1992, and even with the recent amendments, they rely on definitions like cinema, theater, radio, or television. Think about the child influencers dominating social media right now.
Family vloggers.
Exactly. Family vloggers who monetize their children's daily lives. Kids doing toy unboxings on YouTube, generating millions of dollars in ad revenue.
It is a regulatory Wild West out there.
Completely wild. How do these strict labor laws map onto a family operating out of their living room with a smartphone? Is a monetized YouTube channel technically television under this act?
That's the big question.
Does a family vlogger need a DOL permit and a continuing skill acquisition program for their toddler?
It is a massive legal gray area that courts globally, not just in the Philippines, are scrambling to figure out right now.
Because technology has completely outpaced the definitions of labor.
It has. But while the legal system wrestles with the digital creator economy, it remains incredibly absolute on traditional advertising.
Right, there's no gray area there. The law places a total uncompromising prohibition on employing child models in any commercials or advertisements promoting alcoholic beverages, intoxicating drinks, tobacco, its byproducts, and violence.
Zero exceptions.
A company cannot use the innocence of a child's image to market a highly addictive or harmful substance.
Absolutely not. And, for the working children who inevitably fall through the cracks of the formal school system.
Because despite the laws, severe poverty does drive children into the informal labor market.
Right, it happens.
Yeah.
But the state mandates an alternative. The Department of Education is legally required to design specific, non-formal educational programs.
Okay, what do those look like?
Well, these courses must be aimed at promoting the intellectual, moral, and vocational efficiency of working children who haven't finished elementary or secondary education.
It's a beautifully pragmatic safety net. It doesn't just criminalize the harsh reality of child labor and walk away. It legally mandates the state to build a pathway to intellectual development for the kids caught in the gears of poverty.
It's recognizing the reality on the ground.
Exactly. Now, this friction between strict laws and complex realities leads us to our next major area. We've discussed the economic environment, but what about the cultural and physical environments?
The extreme context.
Yes. How does this law protect children whose very surroundings are fundamentally different from the mainstream, or worse, are an active war zone? Let's look at extreme contexts.
This is where the law truly has to stretch its capacity for nuance.
Let's look at the protection of children in indigenous cultural communities first.
Okay. The law guarantees these children all the protections and rights under the Act, but it adds a critical defining stipulation.
Which is?
Their protection, survival, and development must be consistent with the customs and traditions of their respective communities.
Which is an incredibly delicate balancing act, right?
Very delicate.
The state is trying to extend its protective reach without turning that protection into a tool for cultural assimilation or erasure.
Precisely. Because historically, state intervention in indigenous communities has often been deeply colonial, forcing assimilation under the guise of civilizing or protecting the youth.
Right.
This law attempts to subvert that entirely. It mandates an alternative system of education that is entirely culture-specific and relevant to the needs of their communities.
It even dictates that indigenous health practices must be respected and recognized in the delivery of state health services.
Which is fascinating from a policy standpoint.
But I have to ask about the practical application of this. I mean, how does the state balance standard medical intervention with respecting indigenous health practices if the two happen to come into direct conflict?
That's the tough part.
Like, what if an indigenous practice is deemed medically ineffective or even harmful by modern clinical standards, but it is deeply sacred to the culture's belief system? Which part of the law wins? The mandate to protect the child from physical harm or the mandate to respect the tradition?
That is the exact friction point that makes indigenous rights legislation so incredibly complex to enforce.
I can imagine.
If we look closely at the text, it says the delivery of basic social services and health is a priority, but indigenous practices must be respected and recognized. It implies a deeply collaborative rather than a top-down authoritarian approach to welfare.
So the state can't just storm in.
Right. The state cannot just bulldoze into a community with Western medicine and criminalize traditional healers. They are legally required to work with the community elders. In fact, another section of the law mandates that indigenous leaders must be involved in the planning and decision-making for all government programs affecting them.
It's about finding that difficult, negotiated intersection where the child survives and physically thrives, but doesn't lose their cultural identity in the process.
It requires building immense trust, not just dictating federal rules from a distance.
And that need for complex, highly sensitive protection is magnified 100 times over when we look at the next extreme context, children in situations of armed conflict.
Oh, absolutely. If we connect this to the broader landscape of global justice, the declarations in this specific section are some of the most profound legal concepts you will find in international humanitarian law.
The text explicitly declares that children are hereby declared as zones of peace.
Zones of peace.
It's such a powerful phrase. It attempts to physically change the geography of war.
And it's not just a lofty, empty sentiment either.
No, the law immediately backs it up with hard, tactical rules. Children cannot be the object of attack. They cannot be recruited into the armed forces or any armed civilian groups. And crucially, they cannot be used as guides, couriers, or spies.
To understand why this is so specific, you have to look at the history of insurgencies and armed conflict, not just in the Philippines, but globally.
Right.
In guerrilla warfare, children are frequently exploited by armed groups precisely because they are unassuming.
They blend in.
Yes. A 10-year-old can slip through a military checkpoint unnoticed. They can carry coded messages, smuggle ammunition in a backpack, or act as scouts without immediately drawing sniper fire.
So the law recognizes this grim tactical reality and heavily criminalizes the exploitation of a child's innocence for military advantage.
It does. And it extends this zone of peace concept to the physical infrastructure that children rely on.
Schools, hospitals, rural health units.
Absolutely cannot be utilized for military purposes. An army battalion cannot set up a command post in a kindergarten. They cannot use a maternity ward as a supply depot.
It is a legal attempt to immunize the physical spaces of childhood from the theater of war. The combatants are literally forced to fight around the infrastructure of the youth.
And if a conflict does escalate to the point where an area must be evacuated, the law dictates exactly how those evacuations must be handled.
Children are given priority. They must be accompanied by responsible adults, and the state is mandated to keep families together at all costs.
But out of all these rules,
Yeah.
the part that absolutely broke my heart and also gave me immense respect for the sheer empathy of the drafters is the mandate regarding the conditions inside those temporary evacuation shelters.
Oh, I know exactly what you're talking about.
In the middle of detailing food rations, sanitation, and medical triage, the law mandates this. Whenever feasible, children shall be given opportunities for physical exercise, sports, and outdoor games.
It is an extraordinary detail to include in a law dealing with war.
It really is.
Think about the sheer, unimaginable psychological toll of growing up in an active armed conflict. Your village is a literal war zone. You have lost your home. You are sleeping on the floor of a crowded temporary shelter.
It's pure trauma.
And in the middle of that trauma, the law legally mandates that the adults running the camp must find a way, must carve out the space and time to let the children play sports.
It is a desperate, beautiful attempt to artificially create a pocket of normal childhood.
It's an attempt to preserve a shred of that intrinsic dignity we talked about at the very beginning, even when the world around them is quite literally burning down.
It reinforces the core philosophy that survival isn't merely about maintaining a pulse and distributing calories, It's about psychological survival. The spirit has to be protected just as fiercely as the body.
So profound.
And perhaps the most empathetic, philosophically advanced legal stance in this entire text is found in how the state treats children who actually cross the line.
Right, because despite the zones of peace declaration, the tragic reality is that children do get recruited by syndicates and rebel groups.
They do become combatants. They do become spies.
So what happens when the state captures a 14-year-old who is actively shooting at its soldiers?
Well, in many historical contexts and in many current conflicts around the world today, that child would be summarily treated as a traitor or an enemy prisoner of war.
They'd face a military tribunal, a firing squad, or decades in a high-security military dungeon.
Exactly. But under this law, if a child is arrested as a combatant or a spy, the entire legal machinery shifts gears.
How so?
They are granted immediate, highly specific rights. They must be detained entirely separate from adult offenders to prevent further radicalization or abuse. They are granted immediate free legal assistance. And crucially, they must be released within 24 hours to the custody of the DSWD.
And the culmination of that judicial process is the most striking part of the law. Let's say the court examines the evidence and finds that the child did, in fact, commit the acts.
They really were acting as a courier for an armed group.
Right. The court determines what the penalty would be, but then, instead of pronouncing judgment of conviction, the court shall suspend all further proceedings.
They suspend the sentence entirely.
The child is not branded a felon and sent to a military prison.
No. They are committed to the care of the DSWD or a specialized training institution until they reach the age of 18.
The state looks at a child who took up arms against it, and instead of seeing an enemy combatant to be crushed, it sees a profoundly exploited victim who requires intense rehabilitation, not retribution.
It is a stunning display of grace written directly into a penal code.
It proves that the concept of a zone of peace isn't just a geographic location you draw on a map, It's a legal status granted to the child's mind, their trauma, and their future.
That's perfectly said.
But, of course, a beautifully written law full of empathy, grace, and incredibly strict penalties is completely useless if it just sits on a shelf.
It has to be operationalized.
Exactly. Which brings us to the final critical piece of this puzzle, enforcement. How does this massive legal architecture actually mobilize when a threat is detected? Let's look at the remedial procedures and penalties.
Right. The enforcement mechanism starts with a fundamental, often overlooked question in law. Who actually has the standing to sound the alarm?
Who is legally allowed to file a formal complaint to start the judicial machinery?
Exactly. The law lists the usual expected parties, the offended child, their parents or guardians, certified social workers, or the local barangay chairman.
We should quickly explain what a barangay is for context, because it's unique to the Philippines and crucial to how this works.
Yes. A barangay is the smallest administrative division in the Philippines. You can think of it as a localized neighborhood or a village district, but it has actual political and quasi-judicial power.
Okay.
The barangay chairman and their council are community leaders who handle local disputes and administration. They are the absolute front line of government.
So they have the power to file a complaint. But then the law adds a truly revolutionary clause.
Yes.
A complaint can also be filed by at least 3 concerned responsible citizens where the violation occurred.
That is brilliant legislative engineering. It is designed to completely bypass the bystander effect.
Right, because in so many tragic cases of abuse, neighbors might hear shouting through the walls. They might see a child looking malnourished or locked outside. But they hesitate to get involved.
They tell themselves it's a private family matter.
Or they assume they don't have the legal standing to officially report it to the police without, hard evidence.
But by legally codifying that any 3 concerned citizens can join together to file a formal, actionable complaint, the state is legalizing and weaponizing community intervention.
It distributes the responsibility.
The state is essentially saying to the neighborhood, if you and 2 neighbors see something wrong, you do not need to wait for a social worker. You have the full power of the state behind you to demand an immediate investigation.
It makes you wonder, doesn't it? If you heard something disturbing happening next door, would you actually be willing to walk over to 2 other neighbors, organize and sign a legal document to activate this massive protection system for a child you barely know?
It brings the abstract, high-level theory of the law directly down into the personal courage of the everyday citizen.
And once that community courage is activated and a case begins, the law immediately throws a heavy blanket of confidentiality over the victim.
To protect them from the fallout.
Yes. The law institutes a strict media blackout. At the instance of the offended party, their name is permanently withheld from the public record.
But it goes much further than just redacting a name.
It does. It makes it unlawful for any editor, publisher, reporter, or TV producer to cause undue and sensationalized publicity of any case of violation of this act, which results in the moral degradation and suffering of the offended party.
Now, as someone who deeply values the free flow of information, I find this clause highly debatable.
Really? Where exactly is the line between hard-hitting investigative journalism bringing a powerful predator to light and sensationalized publicity?
That's exactly the issue. Doesn't the broader public have a fundamental right to know if there's a trafficking syndicate operating out of a local hotel?
Couldn't a corrupt, high-ranking official who gets caught abusing a child use this exact media blackout clause to silence reporters and bury the story?
It's a very tight, highly controversial legal needle to thread, constantly balancing freedom of the press with the psychological rights of the victim.
But notice the specific qualifier the law uses. It targets publicity, which results in the moral degradation and suffering of the offended party.
So it's focused on the victim's experience of the coverage.
Right. The law isn't strictly banning the factual reporting of the crime itself or the trial of the abuser. It is banning the explicit exploitation of the victim's trauma for media ratings or clicks.
The absolute priority is the psychological recovery of the child.
Ensuring they don't have to relive the intimate details of their abuse on the evening news or plastered across social media.
The state is willing to aggressively restrict press freedom if that freedom is actively harming the child's recovery.
Exactly. The public's morbid curiosity never outweighs the victim's right to anonymity and dignity.
It makes the hierarchy of rights crystal clear.
The child's recovery comes first, the headlines come second. And when it comes time to finally punish the offender, the law lays out common penal provisions that are entirely merciless.
Particularly to those who hold power or trust.
Yes. The law relies heavily on aggravating circumstances. In legal terms, this means that if certain conditions are met, the judge doesn't have a choice. The absolute maximum penalty is automatically imposed.
For instance, if you are a previous convict, you get the maximum. If the offender is a corporation, the responsible officer or CEO gets the maximum.
And crucially, if the perpetrator is a parent, an ascendant, a legal guardian, or a step-parent.
The very people who are supposed to be the innermost, most trusted layer of the child's protection.
Right. They automatically get the maximum penalty. The ultimate betrayal of trust is punished to the absolute fullest extent of the law.
Furthermore, if the offender happens to be a public officer or government employee, not only do they receive the maximum prison sentence, but they also face absolute perpetual disqualification from holding any public office.
The state surgically purges them from the system.
And if the offender is a foreign national, they are deported immediately after serving their entire sentence and are forever barred from re-entering the country.
The system locks them up strips them of power, and then literally banishes them.
It's extremely thorough.
But it's not just about locking people in cells, it's also about extracting restitution. I am fascinated by the follow the money aspect built into this.
Yes, the financial penalties.
Any financial fine determined by the court isn't just dumped into the government's general treasury to build roads or something.
No, it serves a specific purpose.
The law mandates that it is administered as a specific cash fund by the DSWD, and it must be dispersed directly for the physical and psychological rehabilitation of each child victim.
It's a closed-loop system of justice.
The financial wealth extracted from the abuser directly pays for the therapy, the education, and the recovery of the abused.
It's brilliant.
And to ensure this entire massive system doesn't just sit in a dusty law book waiting for a crime to happen, we have to look back to the recent amendments in RA 1648.
The education mandate.
Yes, it added a powerful, highly proactive education mandate. It legally requires that all public and private institutions engaged in basic education ensure their staff are actively trained to identify, respond to, and report sexual offenses.
The teachers are actively trained to be the highly sensitive sensors on this protection network.
Yes, and it mandates that the Department of Education include age-appropriate subjects concerning rights and protection of children directly into the basic education curriculum.
That is the ultimate form of empowerment.
It really is. The law demands that children be taught exactly how this protection system works, so they know inherently what their rights are, what their intrinsic worth means, and when an adult is violating them.
It closes the loop entirely.
From philosophically defining the crime, to economically punishing the ecosystem, to rehabilitating the victim with the abuser's money, to educating the next generation on how to spot the threat.
We have covered an immense amount of ground today.
We really have. We started by looking at how this legislation, RA 7610, and its modern amendments, shifts the definition of childhood from an age to a metric of vulnerability.
Fiercely defending the intrinsic dignity of a human being.
We journeyed through the harsh, highly lucrative economic realities of syndicates and trafficking, and saw how the law attempts to bankrupt the entire supply chain.
Utilizing those proactive attempt clauses, like legal smoke detectors.
We navigated the complex gray areas of child labor and the entertainment industry, seeing the state act as a hyper-vigilant supervisor demanding long-term education in exchange for work.
We stepped into the profound tragedy of armed conflict, witnessing a law that declares children as absolute zones of peace.
Offering grace, suspended sentences, and rehabilitation instead of a firing squad to child combatants.
And finally, we saw how this entire architecture is enforced by legally empowering everyday neighbors to act.
Silencing sensationalist media to protect trauma and forcing abusers to fund the recovery.
If we synthesize all of this, the real insight is realizing that RA 7610 and RA 11648 aren't just a list of severe punishments.
No.
They are a living, breathing declaration of a society's highest values. By defining abuse not just as physical harm, but as anything that demeans a child's intrinsic worth, the law treats child protection not as a specialized police matter,
but as a collective, unavoidable daily duty for every citizen, every business owner, and every teacher.
Exactly.
It is a staggering piece of societal engineering, built entirely out of words.
Truly staggering.
But as we wrap up, I want to leave you, our listener, with a final, lingering thought to explore on your own.
Always good to end on a question.
We saw how the recent amendments had to raise the age of maximum protection from 12 to 18 to catch up with our modern understanding of adolescent neuroscience. They had to update the system to match the science.
Right.
But right now, digital technology is advancing infinitely faster than any legislative body can draft a bill.
That's for sure.
So we have to ask ourselves, as we move deeper into the century, what does an indecent show or an unreasonable deprivation of basic needs look like in the age of AI-generated content?
Or deep fakes, virtual reality environments.
Extreme digital isolation. How will the laws of tomorrow need to rapidly evolve to define and protect the intrinsic worth of the digital child?
It's a daunting frontier. The vectors of the threats will constantly change, but the fundamental moral imperative to protect that intrinsic dignity has to remain absolute.
The blueprint will have to be redrawn again and again. The definitions will have to adapt, because the foundation, the necessity to protect the most vulnerable among us, is permanent. Thank you for joining us on this deep dive.
Welcome to the debate. Imagine a law designed from the ground up to protect children from the crushing developmental weight of extreme poverty.
Right.
But then imagine that exact same law slapping a family with a devastating 100,000 peso fine, and even threatening the parents with prison time.
Oh, wow. Yeah.
Just because their 14-year-old child helped out at the family farm without the proper government paperwork. Today, we are looking at Republic Act number 7610, along with its amendments.
Yes.
For those following along, this is the comprehensive Philippine law providing special protection to children against abuse, exploitation, and discrimination.
And it is a genuinely fascinating piece of legislation, honestly, because it explicitly forces us to confront this massive tension. When you read the text, it creates a highly prescriptive, heavily bureaucratic framework.
It really does.
Right. It allows the state to completely override parental authority. It lets them tightly regulate the microeconomics of a family unit, all in the name of safety.
Which brings us to the core of our discussion today. We're looking at whether this law's uncompromising mandate of state intervention actually serves as a necessary, foolproof shield for vulnerable children.
Exactly.
I'll be making the case that strict regulatory guardrails and uncompromising state oversight are the only effective deterrents against child exploitation, because, well, good intentions just aren't enough to keep a child safe.
I look at this exact same law, and I see a system where heavily bureaucratic and punitive mechanisms risk alienating and frankly further destabilizing the incredibly vulnerable families it intends to protect. I'll be arguing that applying rigid formal sector punishments to informal sector survival mechanisms often fractures the very families the state is trying to save.
To start, I want to look at the foundational philosophy that drives my perspective on this. It's codified right at the beginning of the act. The text states, unequivocally, that the state shall intervene on behalf of the child when the parent or guardian fails or is unable to protect that child.
I mean, on paper, that sounds perfectly reasonable.
I look at it as a vital, non-negotiable philosophy. The law practically defines the best interest of the child through measurable limits, rather than leaving it to the subjective, often flawed preferences of a family.
Okay, but how does that look in practice?
Well, for example, if a child under 15 is allowed to work under exceptional circumstances, the law sets strict maximums, no more than 20 hours a week, and absolutely no more than 4 hours on any given day.
And absolutely no night work.
Precisely. No work between 8 in the evening and 6 in the morning for those under 15. This isn't just a friendly suggestion from a social worker. It is a statutory limit.
Right.
Furthermore, the requirement to secure a work permit directly from the Department of Labor and Employment, DOL, ensures that the state actually has a mechanism to enforce these hours. Without these rigid limits and the absolute necessity of DOL oversight, exploitation isn't just a risk. Historically speaking, it is an inevitability.
Look, I acknowledge the absolute moral imperative of protecting children from exploitation. No one listening to this disputes that goal.
Of course not.
But we have to critique the law's execution here, because it is overly prescriptive to the point of being completely blind to socioeconomic realities on the ground. If you read the text closely, there is a profound paradox embedded right in its early provisions.
How so?
Well, the law explicitly defines circumstances which gravely threaten a child's development, right? And it specifically names, quote, living under conditions of extreme poverty. So the state openly acknowledges that poverty itself is the grave threat.
Yes, they do.
Yet the solutions provided by this legislation are intensely punitive toward families experiencing that exact poverty.
That's an interesting point, though I would frame it differently. The penalties aren't punishing poverty itself. They're designed to deter the behavior that exacerbates the poverty trap.
Which is?
The commodification of the child's labor at the expense of their education and development.
But look at the penal provisions outlining the consequences for violating employment conditions. If a parent violates these rules, they are subjected to fines ranging from 10,000 to 100,000 pesos, or even imprisonment.
Right.
We have to contextualize this. We are talking about families who might be making maybe a few hundred pesos a day in the informal economy. They're struggling just to put rice on the table.
I understand the struggle. But
levying 100,000 pesos fine on a family struggling with extreme poverty does not rehabilitate the family unit. It criminalizes the symptoms of their poverty. It assumes malicious exploitation, where in reality, there is often only desperate, day-to-day survival.
Let's follow that thread then. If we move from the broad philosophy of intervention directly to the threshold where the state actually steps in and severs family ties, we can see why these firm lines are drawn.
Okay.
Because I believe this is where the law's rigidity is most necessary. The law states that anyone who induces or offers a minor to someone prohibited by the act, for instance, bringing a child into a beer joint, a cabaret, a massage parlor, or a prostitution front, faces severe penalties.
Yes, those are abhorrent situations.
But crucially, if the perpetrator is a parent or guardian, the penalty includes the absolute loss of parental authority over the minor.
Which is the ultimate, most devastating sanction a state can impose on a family. We are talking about the legal destruction of the family unit.
And I view it as a necessary amputation of a toxic relationship. Think of this framework like a strict building code for human development.
A building code?
Yeah. Just as a city won't let you build a house without permits because a collapse harms the public, the state cannot allow parents to raise children in hazardous conditions because a developmental collapse harms society. Severing that parental authority isn't a punishment for the sake of punishment. It is literally pulling the child out of a collapsing building before it crushes them.
I come at it from a different way. The building code analogy assumes that the state has a perfectly safe, sterile, and supportive alternative structure ready and waiting to house the child.
Well, they have the DSWD.
Right. The law mandates that the offended party shall be immediately placed under the protective custody of a Department of Social Welfare and Development. But the immediate severing of parental authority and the institutionalization of the child rests on this immense, often flawed assumption.
What assumption is that?
That the state is inherently a better parent than the biological family. We are talking about government agents walking into a home, taking a child from their parents, and placing them in a state-run facility. The law treats this like voiding a business contract, but we are talking about tearing apart a human family.
I'm not convinced by that line of reasoning because the law explicitly prioritizes the child's right to normal development over the parent's right to authority. If the home environment involves offering the child to places of ill repute, the threshold for rehabilitation has already been breached.
I mean, sure, for extreme cases.
The state isn't acting as a perfect parent, no. It is acting as an emergency triage unit.
But it applies this clinical removal to areas that are incredibly broad. The law covers conditions prejudicial to the child's development. What does that actually mean in practice?
It means environments that actively harm them.
But when we treat the severing of family ties as a rapid administrative action, we completely ignore the profound psychological trauma of parental separation. A state institution, no matter how well-funded or well-intentioned, is still a bureaucracy.
It provides safety, though.
It operates on shift changes and case files, not unconditional love. It is not a family. The law mandates this clinical removal without adequately addressing whether the child's emotional survival might be better served by heavily supporting and rehabilitating the home environment rather than legally destroying it.
If the state is going to act as this rigid inspector for human development, we have to see what happens when that inspector shows up at a family's front door for everyday economic activities. Let's look at how this law regulates working children.
Let's do that.
Because that is where the rubber really meets the road regarding state intervention versus informal reality.
Absolutely. Because the section outlining the exceptions for when a child below 15 may actually work is where the formal bureaucracy truly collides with informal reality.
The law outlines very specific exceptions, though. It requires that the child works directly under the sole responsibility of their parents.
Right?
It requires that the parent provides prescribed primary or secondary education, and, crucially, that they secure a work permit from Dole before engaging the child in any work. The intent is entirely focused on ensuring the child isn't being pulled out of school to become a laborer.
I'm sorry, but I just don't buy that. Let me tell you why. Let's break down what this actually looks like on the ground. Picture a family operating a small Sari store.
Okay, a neighborhood stall.
Right. A tiny, informal convenience stall attached to the front of their house. Or imagine a family running a small plot of farmland in a rural mountainous province. The law demands that before a 14-year-old can help at that family stall or help harvest vegetables, the parents must navigate the formal government bureaucracy to secure a dole work permit.
Yes, they need a permit.
But they have to travel, sometimes taking multiple jeepneys for hours just to reach a regional office. They must document that they are providing education, fill out forms they might not fully understand, and interface with a highly formalized system. That system is often completely inaccessible to marginalized, poorly educated, or geographically isolated populations.
But again, the intention is to create a checkpoint so that the child's education isn't sacrificed for the family's economic gain.
But the reality of creating an impossible bureaucratic hurdle for informal microbusinesses is that it doesn't magically stop the labor. The family still needs the child to help harvest the crops to survive. It merely drives the labor underground.
You think it makes it worse?
Yes. When a law demands formal sector compliance from informal sector realities, vulnerable people don't suddenly become formal. They simply hide. They avoid social workers. They avoid government assistance programs because interacting with the state now carries the terrifying risk of a massive fine or the loss of their child.
I see why you think that, but let me give you a different perspective. You cannot read the DOL permit requirement in a vacuum. You have to read it in conjunction with the provisions covering the prohibition against worse forms of child labor.
Okay, but those are extreme cases again.
But the bureaucracy you are calling an impossible hurdle is not just red tape. It is the fundamental diagnostic mechanism that allows the state to differentiate between harmless chores and lethal exploitation.
A diagnostic mechanism?
Yes. How else does the government know if a child is just helping out at a neighborhood stall, or if that child is being subjected to debt bondage, forced labor, or incredibly hazardous conditions?
I agree that the law lists some very extreme, abhorrent conditions that need to be stopped.
Exactly. And those conditions often masquerade as family businesses. The law explicitly prohibits work that exposes the child to biological agents, bacteria, viruses, or dangerous machinery and explosives.
Like the fireworks industry?
Right, pyrotechnic products. In the Philippines, children have historically been exploited in the informal firecracker industry in certain provinces. From the outside, packing gunpowder into paper tubes looks like a family business operating out of a backyard, but it is deadly. A spark can level the entire compound.
That's true.
So the dole permit acts as a vital diagnostic tool. If a family cannot prove to the Department of Labor that their environment is safe, they absolutely shouldn't have a child working in it. The friction of the bureaucracy is a feature, not a bug. It forces a pause, an inspection, and a verification to prevent irreversible harm. A case file might be bureaucratic, but it is better than a morgue.
That is a very fair defense of the permit when we're talking about identifying truly hazardous environments like pyrotechnics or chemical exposure. If the law stopped there, I would be entirely on board.
But you don't think it does?
No, because the law doesn't stop at regulating the physical safety of the work environment. It extends its reach deep into the financial micromanagement of the family unit itself. Let's shift from the act of working to what happens when a child actually generates significant capital.
You are talking about the sections dictating the ownership and administration of a working child's income. I actually view this as one of the most innovative and genuinely protective aspects of the entire framework.
Innovative? It's incredibly intrusive.
Well, the law clearly states that the income belongs to the child. It must be set aside primarily for their support, education, or skills acquisition. And then it brings the hammer down on financial exploitation.
You mean the trust fund mandate?
Exactly. If a child makes at least 200,000 pesos annually, say through acting, modeling, or highly successful legitimate enterprises, the parent or guardian is mandated by law to set up a trust fund for at least 30% of those earnings.
And it doesn't just ask them to set it up. They have to render a semi-annual accounting of that fund directly to Dole.
Yes, twice a year, they must prove to the government with receipts and bank statements that the child's wealth is secure. It is a brilliant safeguard. We have all seen the cultural tropes of the stage parent who works their child to the bone only to squander every single peso on their own lavish lifestyle.
Sure, stage parents exist.
This legally enforces the child's future security. Furthermore, the law mathematically limits the amount of the child's income that can be used for the collective needs of the family to a strict maximum of 20%. It mathematically prevents the child from becoming the primary breadwinner.
That's a compelling argument, but have you considered the profound cultural and economic assumptions embedded in those specific percentages?
Assumptions? It's just protecting their money.
But the state is dictating family resource allocation with a very rigid mathematical formula, a maximum of 20% for the collective needs of the family. I want you to imagine a family that is deeply impoverished, perhaps dealing with a catastrophic medical emergency.
Okay.
A parent or a sibling needs life-saving surgery. The family pools every resource they have. It's a concept deeply embedded in Filipino culture, known as bayanihan, this communal carrying of the burden.
I'm familiar with it.
So the child lands a lucrative acting role or maybe a massive opportunity in a safe, legitimate enterprise. The state steps in and says, even if it means your family loses their home, even if it means you cannot pay for your siblings' hospital bills, you cannot use more than 20% of this child's income for the family.
But the law explicitly states the income belongs to the child. It is protecting the child's individual right to the fruits of their own labor.
But it overlays a highly westernized, hyper-individualistic view of property and wealth onto what are often communally structured, low-income or indigenous families. In many of these cultures, survival is not individual, it is collective.
Right, but
The family unit survives together or it starves together. By walling off the child's resources with strict percentages and semi-annual dole audits, the state is essentially declaring that the child's individual financial accumulation in a bank account is more important than the immediate physical survival of the family unit as a whole. It's an incredibly paternalistic overreach.
I understand the cultural argument, I really do. But the alternative is essentially indentured servitude to one's own family. If we don't cap the contribution at 20%, the child is continually incentivized, or worse, emotionally coerced into working harder and longer hours simply to float the entire household's debt.
Coercion is different from communal survival, though.
But the state is taking the paternalistic role precisely because the biological parents have an inherent conflict of interest when they are directly financially benefiting from the child's labor. By forcing the 30% trust fund and limiting the collective contribution, the law ensures that when this child reaches the age of majority, they actually have something to show for their lost childhood.
Instead of zero.
Right, rather than waking up at 18 to find their earnings were entirely absorbed by family debts.
I understand the logic of preventing exploitation by stage parents. I really do. But again, legislation must be judged on how it applies to the margins and the desperately poor, not just the wealthy anomalies.
We have to protect everyone, though.
But we are talking about subjecting incredibly nuanced, painful human struggles to inflexible percentages if a family fails to submit their semi-annual accounting to dole, or if they desperately dip into that trust fund to pay off a loan shark threatening their lives. They are now violating the law.
Technically, yes.
They are subject to fines, community service, and imprisonment. The state has created a legal architecture that looks flawless in a textbook, but is practically oblivious to the messy, desperate reality of human survival.
But that theoretical architecture, that firm line in the sand, is exactly what pushes a society forward and forces it to prioritize its most vulnerable.
At what cost, though?
Let's pull back and look at what we've unpacked today. RA 7610 and its amendments construct an exacting objective standard, from the precise hour limits, 20 hours a week, no night work, to the required government permits that diagnose hazardous environments.
Yeah.
And even to the immediate severing of parental authority when a child is offered to physical or moral danger. I maintain that these mechanisms provide an indispensable, evidence-based fortress around a child's right to normal development. The strictness is the point. The bureaucracy, as frustrating as it might be, is the shield that ensures a child is treated as a human being with rights rather than a commodity.
And my position remains that while the law is undeniably successful in targeting abhorrent, undeniable abuses like trafficking, pyrotechnic labor, and debt bondage, its intricate bureaucratic demands risk massive collateral damage.
Even with the protections in place?
Yes. When you impose heavy fines on people who have nothing, when you require formal permits for informal economies out in the provinces, and when you mathematically cap how a family can survive a medical emergency, you risk imposing an inflexible legal architecture on incredibly complex human struggles.
The state's heavy hand, well-intentioned, can sometimes act as a blunt instrument that shatters the very family structures it is trying to regulate.
Yet, even with this deep philosophical divide, I think it's clear we have a strong point of convergence here.
Definitely.
The text of the law explicitly states that the, quote, best interests of children shall be the paramount consideration in all actions concerning them. Neither of us disputes that profound moral and legal baseline. Our divergence lies solely in the mechanism of how we achieve it.
Exactly. We disagree on whether the state's prescriptive, mathematical approach to human welfare is the most effective tool to realize that paramount interest, or if it acts as a blindfold to the incredibly nuanced socioeconomic context in which these children and their families actually live.
It really highlights the immense value of reading the actual legal mechanics of child protection, rather than just nodding along to the good intentions of a law's title. This material invites a much deeper exploration into how society balances enforcing a strict moral baseline with understanding the deeply rooted, sometimes desperate socioeconomic realities of its people.
It is very easy for a society to agree that children should be protected. It is incredibly difficult to codify exactly how that protection interacts with poverty, culture, and the deeply complicated nature of family bonds.
So as we wrap up our discussion today, we leave it to you to weigh the merits of these perspectives. When we build our societal bridge to carry the next generation, do we rely on the rigid, uncompromising mathematics of state intervention, or do we leave room for the flexible, unquantifiable nature of family autonomy and communal survival? It's a question that demands our careful consideration.